It's the TMZ Behind the Bar podcast with the TMZ lawyers, Jason Beckerman and Derek Kaufman.
Welcome, everyone, to the Behind the Bar podcast, where each week we bring our perspective to the biggest stories in celebrity news. I'm Jason Beckerman.
And I'm Derek Kaufman.
Thanks again for subscribing to the podcast. And for those of you watching on YouTube, play us in the background while you find your phone. Go to the podcast store in Apple or on SoundCloud and just subscribe. It helps us a ton. It helps us grow the show, which we've been doing by leaps and bounds.
Or, listen closely and enjoy it.
There's that option, too.
Yeah, I just want to let you know you don't have to just have it on in the background.
Right, but it helps. I mean, just multitasking. Derek, Oprah's own network launched a couple years back, right? Beset with mediocre ratings, trouble getting on various cable and satellite platforms, and now she's being accused of stealing the concept for perhaps her biggest show.
Yeah, she actually found a superstar, and Oprah's minted a couple superstars, Dr. Phil, and I think she also found Dr. Oz. Well, she found
Barack Obama,
some people say. She also found Ayanla, and she started this show called Fix My Life. It's called Ayanla Fix My Life, where she's sort of a life coach / therapist. She goes around the United States, and she helps people with their lives. She goes into their homes and helps fix their lives.
And I got to tell you, I caught the show for the first time a couple of nights ago, and it is mesmerizing.
It really is.
I could not turn this off.
She's a singular charismatic talent. Ayanla, you just want to watch her. She's got sort of that magnetism, right?
Yeah,
some charisma. Well, someone named Strickland has now sued her, and she sued Oprah saying, you know what? I came up with Fix My Life, and I called my show The Agency, and I actually copyrighted that idea, and it's also about a counselor who travels around the U.S. fixing people's lives, and what you did was you stole my idea. And not only do I know you, how do I know you stole it? Because we were fighting, Oprah, back in 2011 about an entirely separate show, so you know who I am, you know all about my copyrights, and you stole The Agency to make Ayanla Fix My Life.
So this is interesting. This is interesting. Ms. Strickland says that she has had dealings with Oprah in the past. She has litigation with Oprah in the past.
That's
Oprah is aware.
Or at least legal battles of sorts.
Oprah is definitely aware of who she is, and this woman alleges that Oprah, therefore, is aware of the fact that she was creating these treatments for this television show. And the show, much like Ayanla Fix My Life, was also about a sort of charismatic woman who travels around and gives sort of life advice to people. And
now she wants her money. She says this is a huge successful
sounds like there's
show.
A lot of similarities between these two, between the idea and the eventual program that came out.
At least that concept sounds right on. It does sound like she also had this idea. So this got us thinking, because this is not the first one of these. Jason's been here at TMZ a long time. I've been here fewer years, but I've also seen plenty of these cases, these idea theft cases, where people say this hugely successful movie or this reality show or what have you is actually my idea, and the big bad studios stole my idea and they're profiting from my idea.
We see it most often with the show Empire, right? We've had at least 4 separate actually filed lawsuits, not just demands, but filed lawsuits saying, I created the concept for Empire and you Tyler Perry, you went and stole this concept from me.
I think Lee Daniels, actually.
Lee Daniels?
Yes.
Oh, goodness.
Lee Daniels did Empire.
Oh, man.
But they say, you stole my life. I was a kingpin. I was a studio exec, and I had my family and my gay son who was also an artist, and that's my life you're showing out there. You didn't come up with this, Lee Daniels.
Right, and so, but the thing we've noticed is that these lawsuits have been uniformly dismissed to the extent they've gotten to a judge. These Empire lawsuits have been dismissed. And the thing that struck me is going back and researching and looking at all the cases that TMZ has done like this over the years, these cases are uniformly losers. We are yet to see one where somebody who submitted an idea, no matter how similar it was to the idea that eventually became a television show or a movie, they chronically lose. We have not something covered by TMZ because it was too old, but Dan Brown, the guy who wrote the Da Vinci Code, he was accused by 2 authors of stealing their idea for the Da Vinci Code. Losers. Walk of Shame, that 2014 or 15 movie with Elizabeth Banks,
who I adore.
Somebody said, hey, that was my idea. You stole it from me. That was a loser case.
That one's curious, right? Because the movie is terrible.
The movie is unbelievably bad. I think
even Elizabeth Banks thinks it's terrible.
Oh,
sure. we're not going out on a limb here.
I'm sure she does. That movie it's remarkable to me that anybody would actually come up and say, hey, that was my idea first. Because if you've actually seen the way it was executed, you want nothing to do with it.
You know that trashy idea that was poorly executed? All mine over
and
here.
And lost millions of dollars? Yeah, that was mine.
We also saw the movie Her. Remember the movie Her where Joaquin Phoenix falls in love with Scarlett Johansson's voice as an operating system?
Yeah.
Well, a couple guys came forward and said, we had a movie called Belve. And it was also about a guy who walks around with an operating system in his front pocket. I remember they thought that detail, which was shared by both movies, they also, I don't think, came out on
But
top.
it is remarkable because a lot of these cases, the Her case is a particular example, and also some of the Empire cases as well, the factual details are spot on.
Striking, Jason.
It's almost hard to believe that the eventual what was made was not in some way based on what came before it, because again, the similarities are so striking.
I'll tell you the most striking example. We recently had the Beyonce Lemonade video, and this short filmmaker came in and he did a slide-by-slide comparison of her Lemonade video, which was gothic, black and white, lots of film techniques, and he said, this is my short film, which was about a depressed white guy and his breakup or what have you, and he said she basically stole it. But she won that lawsuit, and these were very similar. Close-ups that were the same, pull-outs, and different imagery, all the same in both videos. And you know what? She won that case because she might have been inspired by it. It did look like she'd seen it, but that's not enough.
So Beyonce's big, obviously, maybe the biggest star in the world, right? Not as big as Isaac Newton, I think you'll agree.
I don't think. Very few are.
Just to nerd out for a second. In 1704, Leibniz, Gottfried Wilhelm Leibniz, went after. He didn't actually sue, but he tried to give a black stain on Isaac Newton's reputation by saying that Newton, in his book Optics, stole all of his ideas for calculus.
Wait a minute, that is actually they independently created it. Don't throw shade on Leibniz. Leibniz might have come up with calculus.
But here's what pissed off Leibniz the most. Newton referred to himself. This put Donald Trump to shame as the father of calculus. And Leibniz comes along and says, what are you talking about, Ike? I'm the guy who created this.
You're now on a first name, short name basis with Isaac Newton?
But here we go. Once again, impossible to prove your case, Leibniz, because who's more famous in history? Newton. He is well known as the father of calculus.
And Leibniz is a footnote.
Leibniz is a footnote.
You know what? Justice for Leibniz. I stand with Leibniz. I always have. Maybe I'm a bit contrarian. I stand with Leibniz.
Right. So again, I mean, putting the Newton situation aside, we've seen these cases. Many of them seem like really good cases facially, but they turn out exclusively, universally, to be losers. So we wanted to find out why.
Yeah, so what's going on with these cases? I did a deep dive into this. So most of these claims they're called Disney claims. That's the case that it all came from. It's an idea theft case where a creator said, I have a contractual right to that idea, and you stole it because I presented this idea to you, you looked at it, you had access, and then you profited from my idea and never gave me money. Now, there's 4 elements. There's 4 things you got to prove when you come in with a Disney claim.
Right.
And here are the 4 things. So first you have to prove you created it. That this is actually my work of art. Most of the people can say that. They say,
they have a script. They sometimes they've registered it with the Screen Actors Guild or with some other copyright forum, and they've sort of said, establish this as mine.
One of the tricks to say you created it is to send it to yourself in a sealed envelope.
Oh, I like it.
Yes.
With the postmark.
Where it's postmarked, and then you can say I created it at this date because here's a sealed envelope. We'll open it, and here's my screenplay. It's kind of one of the tricks to kind of protect yourself. So you got to say you created it. And second, you have to say you submitted it. That's the second element is I gave it, I sent it into this agency or whoever, to this producer, and so I have proof that I actually sent this.
So in the Ionla situation, that's where this woman says, I had litigation against or legal demands of Oprah back in the day. She clearly knows who I am, knows who my copyright is. So they're establishing that Oprah has some idea about the copyrighted work.
Yeah, we call this access. Basically, this is all lumped into, did they have awareness and access to this work so that they could copy it? The third part is that they have to actually have used the idea, and this often gets attacked because it has to show that they used it and created what they created. And the fourth element is that you have to show that your idea is valuable. This goes to the the walk of shame point. Like, if the movie actually lost money, you might be able to say, yeah, maybe we took this, but what did we take? We took a turd.
Yeah. Okay. Unless the idea was Elizabeth Banks in a yellow dress walking across a freeway, I'm just not going to buy it. There was similarity to that.
That's right. Yeah. So all of these are attacked, and because there's these established things you must prove, the studios know the playbook to go after these ideas. What they do is oftentimes they won't even accept submissions. So since one of the elements is you have to submit it, sometimes they'll put a stop at the door sign and they say, we don't accept unsolicited submissions for precisely this reason. We don't want to be accused of having stolen it. They'll also say, we independently created this stuff.
Yeah.
Ideas are out there, right, Jason? I mean, they're in the ether, so you can say, we actually had a focus group or we had a roundtable discussion and we came up with the idea for this particular.
Right, and you put on the 5 witnesses who still work for the company and said, nope, my idea.
Right.
And the person who actually may have come up with the idea is kind of SOL.
That's exactly right. And so those are the ways that you can really sort of defend yourself when someone comes up and says, you took our idea. You had access and you stole it.
Right. So, again, all these cases are losers, and I think that notwithstanding these elements are very difficult to prove, let's find out from somebody who actually worked in the studio system of why exactly these things are so difficult to prove.
Let's hear from.
So, Derek, we wanted to bring on a true media law expert who might be able to explain to us why these idea submission cases are so very hard to prove. And so Susan Seeger now teaches media law at UCLA after a long stint at
USC.
Did I say UCLA?
Oh,
Yeah.
your biases
My
are
bias
showing,
just showed
Jason.
right through. Yes. Media Law USC, which is the lesser known school in the LA area, right? No, I'm sorry. After a long stint at Fox Entertainment Group, where she defended the studio against the very same types of claims that we're talking about here. Susan, welcome to the podcast.
Thanks for having me.
So, Susan, you repped Major Motion Picture Studio for a very long time. Why is it that you guys always seem to win, these major studios? And we work for a major studio now, and we always seem to win too. Why is it that? What's in the sauce for major studios that we always seem to win these cases?
Well, I think, first of all, a lot of people don't understand copyright law or idea submission law, and they don't sue with a lawyer. They just sue by themselves. And so they haven't even figured out what the law is. So that's one reason the studios win, is people don't understand the law. And then even when they get a lawyer, they don't understand the law either. The lawyers don't, and think that they own an idea, and copyright doesn't protect an idea at all.
So we talked a little bit about that. So can you explain what the difference between an idea and sort of the artistic expression of that idea and how it works in the law?
Well, so copyright doesn't protect ideas. The courts have said ideas are free as the air, and we want to keep, protecting creativity and ideas and discussion. So the thing that copyright protects is once you put that idea kind of into tangible form, like in a play or a screenplay. And I always say that copyright doesn't protect the story; it protects the storytelling. So how do you tell that story with characters and the plot? And so that's what you own, is how you've told the story and how you've written it down. And so that's the main thing plaintiffs don't understand.
So I can copyright the Mona Lisa if I paint it, but I can't copyright a woman sitting with a wry smile on her face, right? I mean, that's just an idea and a concept, and the fixed expression of it is what is actually protectable. Is that a good way of thinking about it?
I think that's one way of looking at it. Yeah, you can't protect an idea that you say, wow, I want to do a reality show about counseling. That's an idea. It's vague, it's generic, it's broad. So you can't protect that idea. Even if you wrote it down, I think it still wouldn't be protected if that's all it is, very vague like that.
Well, I'm glad you brought up an idea of a show with a counselor maybe roving around the United States and helping people with their life. That's the Oprah case, right?
Yes.
So you took a look at this Oprah case and the story that TMZ wrote on it. What do you make of the case? What are the likelihood that you think this plaintiff might actually be able to survive sort of what we in the law would call a motion to dismiss, the first motion that the studio is sure to bring to sort of set this aside and get this case kicked out of court?
Well, based on the complaint, it doesn't look like Ms. Strickland, the woman who sued Oprah Winfrey, will be able to keep her case alive for very long. I think it's subject to an early dismissal motion. And the reason why is to win a copyright case, you have to prove kind of two basic things. And one is that Oprah had access, that she read this woman's work, and two, that she copied it so that they're substantially similar. And I think in this case, she doesn't meet either of those two standards. She doesn't really allege those two things well enough to keep her case in court.
Let me ask you a question. So one of the allegations in this case that made it a little unique for me was she said that she was fighting with Oprah back in 2011 over a different show. And what she says in the lawsuit is, Oprah knows who I am. She's aware of my copyrights. We've fought in the past. So she had full access to who I am and to look up my copyrights. Is that enough to get her a little further in her case than the average litigant who just says, she stole my idea and it was percolating in my head?
Well, it's pretty creative. I think it's kind of interesting, but no, it's not. I mean, if that were the case, then everyone who sent a claim letter to a producer could claim that that meant automatically the producer saw their work. That's pretty ridiculous. It's not enough.
We talk about sort of the slippery slopes of things all the time, right? If you allow this in, what have you then allowed in? And I can see a situation where anybody who writes anything would simply send it to the four corners of the earth.
And says, now you're on notice, everyone.
And said, the whole world, you're on notice, even though there's no direct evidence the person is actually aware of that particular artistic work. Right. And then when it comes out later, that they can tie it to the receipt of that work.
So it's clever, but maybe not clever enough.
Yeah.
Exactly. And I think the other thing is Ms. Strickland doesn't have to show, it's not enough to say Oprah was aware of work. She has to say that she actually saw the work and reviewed the work and copied the work. And so She just doesn't have that at all in her complaint.
So that's the awareness prong, and then the second prong is some sort of similarities between the actual artistic ideas that are contained within the submission. So let's assume for a second that Oprah actually they proved through discovery or through some other mechanism that Oprah actually picked up this treatment, read it from cover to cover, explained to her sidekick, her assistant, boy, I really like this and would like to do something with it. You move forward, but you're saying that's not even enough probably because the allegations in the complaint don't suggest that the similarities are that substantial between the two works of art.
Right, that's correct. And even before you get there, I mean, it doesn't look like she really registered anything that's very particular with the Copyright Office at all. She registered one page with the Copyright Office, and it seems kind of vague, so she may not even have anything detailed enough with the Copyright Office to show she has a valid copyright in this reality show that she had the idea of. But secondly, there's, she doesn't seem as though she alleges they're sufficiently similar in protectable elements. By that I mean you can't claim ownership or copying of an idea. So it seems like she has a general concept of a reality show with a counselor that travels or a team of counselors that travels around the country helping people. And that's just too generic. There isn't enough detail there to really make it be a protectable, copyrighted work.
I think that's a great point because when you take a step back from this case, the show is actually, Oprah's show is Iyanla Fix My Life, right?
Yeah.
And Iyanla is such a singular talent that the show sort of works because Iyanla is going around and talking to people. A general therapist roaming around or Dr. Phil is Dr. Phil, right?
Yeah.
Any therapist on television will not be Dr. Phil. People watch for him. So it seemed a little weak to me to just say the concept of a counselor in and of itself is the show idea. The show idea is really Iyanla on Oprah.
Right. Well, let's say, Susan, I were to come back just after the election and launch the show Ivanka Fix My Life, and it was the exact same thing. Do you think I could get away with that, or am I going to get nailed by the Oprah people for stealing their idea?
I think that would be fine. I don't think that would be copyright infringement anyway.
Wow.
I mean, there's
interesting. Susan, you're
well,
proving.
there's trademark infringement of a title.
Yeah. That might be difficult.
But you can't copyright a title. And I
Right.
think your earlier point is right. Is that this show that Oprah runs, that counselor, Ayanna, how do you say her name?
Iyanla.
Common spelling.
I've seen the show, and it's she is a singular person. She really is.
Oh, interesting.
Oh, you like Super Soul Sunday.
I think we might be proving
Well,
that.
I just love her. She's just fantastic.
She really is. I know. I've seen it.
But maybe we're just proving that you can take the woman out of the studio, but you can't take the studio out of the woman. Just the hardcore defense.
Something
of
like that. Something like that.
Well, thank you so much for joining us. This
Susan
has been great.
Seeger, this has been great. Thank you so much for lending your talent and your experience to our podcast.
Oh, well, thanks for having me.
All right. I love having somebody who knows that much more about us on any specific
It's the best when we're floundering.
when we're
Which is
floundering
often.
and somebody I'm slowing. So, Derek, if I was a budding screenwriter, if I had created a treatment or a screenplay, I would be terrified, based on what we've heard today, to actually submit it to a studio, because the studio, it sounds like, if they accept it, could pretty much do whatever they want with my artistic work, and it would be almost impossible for me to actually pursue that claim and to win that claim. I'd almost be, by sending it in, taking a huge risk that I'm never going to see it again and not get anything for it.
Yeah, look, it's a huge problem, Jason, and there are only so many pieces of advice I can give you. Hollywood's a cruel world. I mean, these are stories are as old as time, right?
Yep.
They go back to Leibniz and Newton. So idea theft is out there, but there are a few things you can do to kind of protect yourself. One is the studios create a paper trail of how they create things. You can create your own paper trail of how you created things and the timing you did that. I brought up the idea of mailing it to yourself in an envelope that's sealed. That kind of stuff is helpful because it puts a timeline on when you created stuff. You give yourself some sort of process that you have rigorously documented. And that can be helpful when you're trying to prove up your case that someone stole your idea. The other two things are register your idea. There's the Writers Guild of America. There's the Copyright Office. These things do afford some measure of protection for your the expression of your ideas and your treatments and your screenplays. So do those things at a bare minimum. They're the only thing that give you a shot. But at the end of the day, you gotta play the studio's game. The studios are there for a reason. They make the movies, they turn them in, they invest into these projects, and they actually turn them into reality. So you kind of have to play that game. And if they have you sign a release, you kind of have to do it. You don't have much leverage if you're a brand new screenwriter. You got to sign the release that says, I won't sue you for submitting my idea. But what you can do is in your submission, you can say, I want to reserve my rights in this submission. And I want to say that I expect to be compensated for this idea. This is not a gratuitous submission.
And I happen to have a very good friend who's written a number of big screenplays in Hollywood, and I asked him about this a while back, and he said, yes, it's a terrifying fear for all first-time writers that they're going to have it stolen. But once you publish something, or I'm sorry, have something purchased and made into a film the first time, the leverage shifts entirely. You are now in the driver's seat because it is so hard to find people who can actually write a script that is made. You know, for every movie that's made, there are tens of thousands of scripts that are read through, potentially even money is spent on them, and they don't materialize. So if you find someone, if you're a writer who's actually got something made, you are now in the driver's seat, and you can call your own shots. So, you know, we all have to just sort of muddle through the first time, hope you don't get screwed, and then time two is when you're really going to get paid and really going to have the
That's
access.
right. If you muddle through and you develop a reputation, you become Aaron Sorkin. They're not screwing over Aaron Sorkin, right? He's got a good agent who they're repeat players. You don't do that because Aaron Sorkin will never work with you again.
And honestly, I think the best piece of advice is anybody is get an agent if you can get one. It's not just a matter of calling up UTA and saying, hey, I want an agent. They're not going to give it to you. But if you can establish your bona fides, write a decent script, you are going to get an agent, and they will protect you. You're not going to get screwed if you have an agent behind you.
Oh, they'll charge you handsomely for this.
Well, you're going to get screwed by the agent.
Right. In general, the 10% they take will feel like a screw job, but at least you'll get something out of the process.
10% of something is better than 100% of zero.
That's exactly right. So I wanted to, before we leave this whole topic, I wanted to talk to you about my favorite one of these. So there's a lot. The road is littered with old cases that don't go very far. They get thrown out on motion to dismiss. So very few of these actually go through the whole process. But one case about ABC's Lost. Do you remember the show Lost?
I loved it.
So there's a famous case against ABC called Spinner versus ABC where a guy alleged that the idea for Lost was stolen from him from an idea he submitted in 1977 to ABC. And he had a script, a 2-hour pilot for a show he called Lost, and he submitted it about people stranded in the Himalayas after a plane crash, and they get sent to this prehistoric world. Sounded a little bit like Lost.
A little bit, yeah.
Right?
You're spot on right
Yeah,
now.
there was sort of supernatural stuff. He wrote the script for $30K. He had a relationship with ABC. ABC passed on the treatments 3 times. And then, lo and behold, several decades later, Lloyd Braun, an ABC executive, comes up with the concept for Lost. And he says, it's a cross between Survivor and Castaway.
Right.
I want to do a whole show on it. He has Damon Lindelof and J.J. Abrams, obviously of Star Wars fame, write the script for him in 2004, and then they launch a pilot, and it becomes a huge show. And this guy says, that's my show, and you had it in 1977. It's the same thing. Supernatural travel, time travel, all that kind of stuff. He actually lost the case.
Of course he did.
Right. So you can't fathom someone with more evidence to bear than this guy.
The title was the same. The concept
studio's
was
the
the same. The studio is the same. They clearly had the script. Lloyd Braun had access to the script.
Absolutely.
He made the show that sounds almost exactly like it in a pseudo-prehistoric world.
Yeah.
No good.
No good.
No
and,
dice.
And the reason is, when you come up against the studios, he had good lawyers too. He said, look, you guys have a script library. You know about my script. I was paid for this. They said, you know what? We didn't look at our script library. I don't know what you're talking about. We don't really do a search for all scripts when we do this. And ABC had a long paper trail of sitting in conference rooms with minutes that said, we developed it here. This was when I talked to JJ. This is when Lloyd came back from vacation on a tropical island, which, by the way, Lost was on a tropical island, not in the Himalayas.
Yeah.
And they said, look, we independently created this. One of the best defenses you have as a studio is to say, yeah, you got a great idea.
Right.
That does sound like a wonderful show, but I came up with it myself because it's just a great idea and it's out there.
If I was some struggling screenwriter sitting in my apartment right now listening to this podcast, I might shoot myself in the face.
It's so disheartening. I read this case and this went through levels of appeal. The guy was incredulous to say, how could you say this studio didn't steal my idea?
Right.
Sure enough, no proof that you stole the idea. Independent creation is a robust doctrine, and he lost.
Usually I'm excited about mail time, but right now I'm just depressed.
Is that like a downer of
That
downers?
is downer.
Anyway, mail time, Parker.
All right, make sure to write into your question.
Well said, Parker.
As always, I'm quite good at reading my own writing.
Can we bring in the Maddie?
Lefty reliever.
Make sure to write in your questions and comments to behindthebar@tmz.com. The first one up is from Kevin Wells, who's asking about Obama pardoning Clinton. How can you pardon someone if they haven't even been convicted?
Oh, good question. You know what? That's the best time to pardon them, actually.
Yeah.
The best time is that they committed the offense. You don't have to be convicted of it. You just have to be accused of it, basically, and you can be pardoned for it.
Richard Nixon classic case had not been convicted of anything. He had actually retired before the Senate had an opportunity to impeach him. And was pardoned just on the allegation of the offense. That is what happens all the time, that pardons are given just for against the potential prosecution for that crime.
It's really to clear
a great
the deck.
question.
You know, Nixon never impeached, just for the record.
Yeah, just because he retired before he could.
And the next one's up from Quentin Marez, talking about Trump opening up libel laws. So now they can just say whatever they want with no repercussions?
Yes, there are limitations. It's not quite whatever they want, but the First Amendment is very protective of media organizations.
Particularly with public figures. Good point. Basically, the standard is, and I think we talked about this last time, the standard is, did the media organization basically know it was false when they said it? And that means that it was a statement of fact. It couldn't just be an opinion. You know, I think politician X is a jerk,
an awful person, the devil, whatever it is. These are statements of opinion. It would have to be a statement of fact, like this person
groped this woman on this day.
Right, and not only that, you must know it is not true at the time that you say it. In order for a plaintiff to win, a plaintiff's a famous person, in order for them to win against a news media organization, they must have known it was false or acted with reckless disregard for the truth. And what that basically means is that you kind of think it's false, you're not quite sure, you have evidence to suggest it's false. You can't say, well, you know what, I'm going to ignore that evidence.
Put my head in the
false.
sand.
Right. That's reckless disregard. But if you have any true suspicion that it's true and you publish it, you are guaranteed protection under the First Amendment.
Yep.
And it's important. I mean, I know it sounds awful, but it's really important because if the news media starts to fear being sued, if they're going to publish something, then they will be less likely to publish it, more reticent to do so, and our system of governance sort of dries up pretty quickly.
Yeah, we were worried about those, what they call chilling effects. We don't want the media to be gun shy. We want them to be the watchdog and get things out there for people to listen to. So the celebrities and the public figures, they just get less protection.
And the celebrities and the public figures have a soapbox. That's the reason the protections for them are so much greater than they are for private individuals, because they can. Donald Trump, if people say bad things about him, he can take out $1 billion ad buy and slam the Washington Post or the New York Times if he wants to. He can do all this. He has a soapbox.
Rallies.
On which
he has a megaphone.
Yeah, and he's an exception, obviously. But all famous people have the platform from which they can speak to decry the allegations that are made against them. And if the public buys it, they buy it. And if they don't, they don't.
And the last one is from Flame Beats. You mentioned Japanese internment camps, but you did not mention the Trail of Tears.
Oh, interesting. That actually, it just didn't dawn on me because it's such an older example, but that's another forced relocation. So you're right. You found another shameful moment in American history where we forcibly relocated an entire race of people.
So 1870s Trail of Tears?
That sounds about right.
1838 to 1839.
Exactly what I said. It's not my fault. My microphone was garbled.
Trail of Tears, obviously the forced relocation of Native Americans, and this is what spawned the reservation system, essentially. Said, we're going to build up these cities. They're going to be for European settlers, and they're not for you anymore, even though you were here first. Gross part of history. Now they're on reservations, and it's sort of a depressing black mark on American history, if you ask me. I know
it's a fool's errand to rate these things in terms of how bad they are, right?
All right, top 10 worst relocations.
What's
Jason?
the Mount Rushmore of awful things the U.S. government has done?
Right. Maybe we shouldn't rate these.
Yeah. All right, that's it for mail time.
That's it for mail time. Well, thanks very much.
Well, way to end on a great note of forced relocations, Parker. Way to stack them.
Right. All right, guys. Thanks so much for tuning in. We will see you again and talk to you again next week.
Thanks, everyone.
Thanks for watching. If you want more nerdy deep dives into the legal side of celebrity news, hit our subscribe button right here.
And check out our previous episodes over here.